we happily have about 15 minutes or so for questions and comments from the audience, and we've heard four very interesting presentations which have taken us across a wide range of dispute resolution issues and possibilities for small states. So let me turn the discussion over to you. Please. And I would ask if you would please identify yourself before asking your question or making your comment. No, no. Please go ahead. I was speaking to the gentleman in the front row.
Okay. Thank you very much for these presentations. I'm Janie Bremy, Sidley Austin, Washington, D.C., formerly of Geneva, Sidley office. I have a couple of questions and a couple of comments. The first is that I was very happy to learn about, especially the participation of small states in the context of investment. But being a WTO practitioner, a couple of things hit me as maybe being points of comparison that perhaps I give you now an opportunity to speak a little bit about. Again, always applying the WTO route. The first one is, the WTO doesn't have these jurisdictional sort of issues that you spoke about, Stephen, because upon signing up to the WTO agreement, states subject themselves to the dispute settlement arm. And so there's no option of opting out or having to expressly consent to jurisdiction. So that's one of the things in favor of small state participation, is that they're not subject to that whimsical withdrawal of consent by countries at the fair outcomes of disputes. The second point that I wanted to make was with respect to the trust fund options in these various international tribunals. I know there is an ongoing proposal by developing countries at the WTO to establish a similar sort of trust fund at the WTO in order to increase participation of developing countries. And I don't know if you've been privy to these proposals, but I'd like to know what your thoughts are on how you pick the best aspects of what's already available out there so that we could put that forward in the WTO context. Talking also about the permanent court for investment that is now being proposed by the EU. I wonder if any of you can speak about how that's going to positively impact small states. So the potential of having a common forum, a court set up to adjudicate disputes in a similar way as the appellate body does in the context of the WTO. If you have any thoughts on how that's going to be a positive development for small states. The third point goes to, I think, Dr. Poulsen, your point. I think Jansen has made a really good point, which is not only did small and developing states not expect the outcomes that happened as a result of these BITs, but also developed countries as well may have been surprised at how investors aggressively utilize the BITs and the problems of regulatory space that they're confronting. And I wonder if you have any thoughts on how small states can take advantage of the constituency among NGOs and civil society now to increase accountability in the resolution of disputes in investment context. And then just finally, for all of you who have worked with small states, I have a very deep concern that what's happening is whilst we're getting the very best representation in these international fora through experts like yourselves, that not much, and that's a question rather than comment, how much of that is being retained in the regions? How much of these expertise are now being grasped by persons that you work for, so that in the next case, whilst they can still retain your services, they can also do some of this representation themselves. So my question is, your experience so far working with small states, how much are you working with persons in the region in bringing these disputes and also in sharing expertise in bringing these disputes? Thank you.
Right, well, I counted 4 questions, so we've really hit a bumper crop. Let's take another from the gentleman in the front row, and then we'll have the panel have a go. I believe this gentleman.
I'm Ian Newell from Kingston University. I was slightly alarmed by some of the comments about the ICJ, that it needed reform, for example, but also that there's a right of intervention by a third party. I wonder if the panel could, enlarge on that particular aspect, please.
Thank you very much. That's 5, so let's turn it over to the panel. Stephen, would you like to start? Any particular place? Take your choice.
Yes, well, going first, I have the luxury of taking a choice, I guess. So I'll exercise that luxury. On the WTO side, I absolutely agree that the jurisdiction issue is often less complex, and there's no ability, unlike in other fora, for states to enter wide reservations to the scope of jurisdiction. It can work both ways, of course, and ironically, the only time I've been involved, I'm not a trade lawyer, but the only time I've been involved in a trade dispute was on the receiving end for a small state. That was for Antigua, on the receiving end of a complaint by the United States about online gaming, much of which was being run through Antigua at the time. And of course, Antigua didn't have an ability to challenge jurisdiction. So in that case, it was actually more of a hindrance to the small state. On the impact of the permanent court, how will it impact small states? Well, I think if there is a permanent court for investment disputes, those who are supporting the proposal say that it will reduce costs. It should reduce costs for small states. There'll be a standing tribunal or court on very, very modest, on the current proposals, standing salaries, albeit they will be paid as and when they are brought in to decide disputes a little bit more. But there's no doubt that they will be cheaper than the standard arbitral rates at the moment. It is said to be, at least on the EU proposal, a more transparent process and one that should lead to greater certainty in judgments and awards, because there should be more consistency in those judgments and awards, in part because there will be this appeal procedure, which I think is based in large part on the WTO model. And another benefit, I think, from the state perspective generally, will be control over the process and the people who are deciding the disputes. Now, that may or may not be a good thing, but what we will see is a move from a dynamic where the appointment of the tribunal in arbitration is very balanced. The investor appoints one arbitrator, the state appoints the other, and then there's some form of agreement normally over a president. In the investment court, it will be states writ large who appoint the members of that court. And for example, on the EU's current proposal, in order to qualify to sit on that court, there are a number of criteria that will much more easily be met by public international lawyers than arbitration specialists. And public international lawyers quite often come from state backgrounds or have sat as, often within foreign ministries of states or otherwise. So the type of person who will be deciding the disputes may be a little bit different, maybe a little bit more uniform, and maybe a little bit more pro-state, maybe. Finally, on expertise in regions, I think it's really important in any dispute where, particularly, for example, I'm working with a government in a faraway region. It may be a small state, to involve as much as possible expertise and resources from that state within the team. You will have no properly functioning team without a very substantial local element. And certainly the best experience I ever had in this respect was the case I did for Barbados, where we really did involve local expertise at all levels of the team. The client itself was a very sophisticated client. The individuals within the Foreign Ministry tasked with managing the dispute were immediately sent on training internationally to get up to speed on the area. So within a few months they knew about the law. They were able to engage with us on an informed basis and to give us informed instructions. We used local experts, including Dr. David Berry, who was here yesterday. I'm not sure whether he's here today, on the team, but also two very senior local lawyers, Adrian Cummings QC and Henry Ford QC. Probably one of the highlights of my professional career was working with Sir Henry Ford on the fishing elements of that case. And he dealt with aspects of it, particularly on the facts, in a way that I could never have done. So I think it's really important to involve local expertise, both for the prospects of the individual case and to leave behind expertise when the international consultants leave.
I'm going to take the chair's prerogative to offer a thought on the EU court proposal and specifically the challenges that it is likely to pose for smaller states. And Vietnam, again, not a small state in terms of population, but a relatively small state in terms of economy. Because I think, as Stephen's right, there is greater control given to the states in the new EU model, not only through the court, but also through the state's ability to submit in cases to which they are not the respondent, so that they have the opportunity to file pleadings with respect to the meaning and application of the treaty, even when they're not on the receiving end of the claim. But I think with that greater control comes greater responsibility and greater obligation, and it's going to require greater capacity. And just to offer a comparator, under the North American Free Trade Agreement, Article 1128, the non-disputing state parties have the right to make submissions to a NAFTA investor state arbitral tribunal. And historically, throughout the 20-year history of the NAFTA, the United States, Canada, and Mexico have actively used that right to submit pleadings to arbitral tribunals in cases in which they are not defendants. Why do they do that? They do that so that they have an influence and a voice with respect to the way in which the treaty is going to be interpreted and applied by an arbitral tribunal, recognizing that the next case may well be against them, and reasoning being the way it is, the arbitral decision in the instant case might be used as a precedent or persuasive citation. Similar provision exists under the Central American United States Dominican Republic Free Trade Agreement. And if you look at the practice of the states there, you will find that the states, being smaller, being less developed, having less capacity, have far less frequently exercised their rights to make submissions to arbitral tribunals to which they are not parties. And what's more, even in situations like TPP, where you have states which are very sophisticated negotiators of treaties because they've been negotiating sophisticated free trade agreements for years, they may not have experience in the litigation or arbitration of claims under those treaties. And those are two very different skill sets. Someone who is familiar and sophisticated in arbitrating claims may not be the good right person for the negotiation of a treaty, and vice versa. So just a thought on the challenges that are posed by the EU court system. Yes, I stole time, so let me give it back quickly to Brian to talk about the proposal that was mentioned.
Sure. With respect to that proposal, it seems to me that the only thing that would serve would be to give developing states their choice of counsel, that they would be taking the funds to purchase the use of private counsel rather than the use of, admittedly, the brilliant minds at the advisory center. I could see why prominent law firms such as yours in trade might be very supportive and perhaps literally supportive of that particular initiative. But I think otherwise we're talking about the gold standard. Least developed countries pay 0 in terms of contributions to the advisory center, and the hourly fee in the midst of the dispute goes as low as $25 an hour. I wish that this could be adapted into some of the other frameworks that I mentioned, like the ICJ, but I think for some reasons that you mentioned, such as dramatic differences in the jurisdictional framework, as well as I think the incompatibility of the WTO with adjudication, that they're reports, they're not judgments. I think it would in fact be very difficult to adapt the advisory center to something like an international bar organization for states at the ICJ. With respect to the gentleman's question, stemming from what Jansen just spoke of in terms of third-party submissions, for example, in the NAFTA framework with the Lowen case and others, very simply, and I have to make this deliberately very simply because I'm frantically trying to finish a PhD on this very topic. There is no right of intervention formally for third parties at the ICJ, with the exception of the construction of multilateral conventions. Going back to the heart of my discussion, by my reading of the ICJ's trust fund's term of reference, there is no possibility for a third party, even one which is a party to the dispute, such as in the construction of a convention, to obtain funds. So that, to me, is problematic. In terms of the kinds of third-party submissions as a non-party that we just spoke of, like amicus-like submissions, there is very little practice and no provision in the rules of court for this in contentious proceedings. There is in advisory proceedings. And finally, in terms of the implementation of the court's judgments, I mentioned that the trust fund permits money for states to implement the judgments, for example, in boundary disputes, to undertake the technical demarcation. But one can see that there is many other kinds of disputes where non-parties to the dispute, which might be said to have a legal interest in the case, are in fact, let's say, de facto bound by the court's judgment in terms of its definitive interpretations of international law, and would do well to conform their state policies accordingly. So the trust fund's provision on restricting implementation to states parties to the dispute is essentially guilty of the same sin of the legal fiction that under Article 59 of the court statute, that those judgments are truly binding only res inter alios acta. They are, in fact, as we all know, much more than that.
Thanks very much. Lauge, do you want to?
There's a couple of questions, right? So the question as to whether or not it was a similar sort of pattern in developed countries, I think that was the nature of the question. It's absolutely true that in many cases, including here in Europe, there has been shock and awe when a reinvestment treaty claim has been filed against Germany, for instance. But I think it's important to distinguish between the politicians and generalists and then the technocrats who actually negotiated the agreements in the first place. And the point I was trying to make was that in many, not all, but in many developing countries, even the so-called technocrats who were negotiating them didn't always appreciate the nature of the beast. That has also been the case in a couple of small developed states. I realize there's a camera on with a little red light on top, so I'm not going to mention which, but there's been a couple where similar sort of patterns has been observed in parts of Europe as well. As to what developing countries can do to overcome these sorts of constraints on expertise, well, one obvious choice is to take outside counsel, even for negotiations. I would caution against that in many cases. So there was an infamous case in the early 1990s where former U.S. negotiator Ken van der Velde, out of the goodness of his heart, offered his expertise to Lithuania after he had retired as negotiator in the U.S. And when he arrived in Lithuania, he realized that the investment treaty program was a mess. Very few had actually taken the time to think through any of the obligations, and they just sort of copy-pasted provisions from various sorts of provisions. So he spent a lot of time and effort trying to train them in what the implications of these agreements were. But when it came to the actual negotiations, the other side of the negotiating table refused him access on the Lithuanian side. So the U.S., for instance, said that it's fine, you're taking Ken van der Velde on board, but he can absolutely not be in the room. And what came out as a result was a treaty that was perhaps not would not have been the same had Kinder van der Velde sat in the room. So that can be difficult. So then, of course, there's a question of insight. What can you do within a development? I think probably the best advice is to pool resources. So a good case of that was in the early UK bid program. The first bids to be negotiated by the United Kingdom in the early 70s was with the Caribbean. And a couple of Caribbean states had decided that because there happened to be a very skilled lawyer in Jamaica, he should negotiate on their behalf. And if you go back to the archives, or if you go down to the queue and look up the records, he did an excellent job, not just for Jamaica, but also many smaller island states in the Caribbean. So I think that might be something that's worthwhile pursuing.
Dominic, you want to bring us home?
Two short points. Capacity building. I think that only fools and rich men rush to law. So I think that capacity building, whilst an honourable intention, should be tempered by the consideration that no state should really want to expect more litigation or arbitration unless it can really help it. Now, there are some states which have made a bit of a habit out of it, and we saw some of the statistics in the slides I presented. And as I mentioned when I spoke, they have got capacity of their own to defend those claims or bring them. Where it gets more difficult is with the smaller states who've only got a record of one or two cases, and I think it's very difficult to train up an army of budding young lawyers, economists, and all the rest of it to deal with the next one that comes through, bearing in mind that very few cases are the same. So I think it's an admirable intention. Whether or not it works for the small state is another matter. The one state which might think about it possibly is Costa Rica, given the rash of claims that have been brought against it. Second short point, intervention. I think it's Article 62 of the ICJ statute that says, should a state consider that it has an interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. And then paragraph 2 says somewhat darkly that it shall be for the court to decide upon this request. The court doesn't have a very good record of deciding upon those requests, although there have been, I think, at least 3 cases where a third state has sought to intervene. All of the ones I can think of are boundary decisions. One was Malaysia and Indonesia, the Sipadan case where the Philippines sought to intervene. I think was told to back off. Cameroon and Nigeria, there was a West African state that tried to get involved and again was told to back off. I think that was Guinea-Bissau, one of the Guineas anyway. And then one of the Libyan cases, it was another intervention application, which again went nowhere. But it's in the statute, it has been exercised, but not terribly successfully. Thank you.
Thank you very much, Dominic. That concludes this panel. All that remains is for us to thank our panelists.